The United Kingdom European Union membership referendum, also known as the EU referendum and the Brexit referendum, was a referendum that took place on Thursday, the 23rd of June 2016 in the United Kingdom and Gibraltar to gauge support for the country's continued membership in the European Union. The referendum result was not legally binding. The referendum resulted in an overall vote to leave the EU, by 51.9% on a national turnout of 72%, making it the highest ever for a UK-wide referendum and also the highest turnout for any national vote since the 1992 UK general election. The result was split between the constituent countries of the United Kingdom, with a majority in England and Wales voting to leave, and a majority in Scotland and Northern Ireland voting to remain. The British Overseas Territory of Gibraltar also voted to remain, to start the process to leave the EU, which is expected to take several years. The British government will have to invoke Article 50 of the Treaty on European Union, but it has not yet done so. Membership of the EU and its predecessors had long been a topic of debate in the United Kingdom. The country joined the European Economic Community in 1973. A referendum on continued EEC membership was held in 1975, and it was approved by 67% of voters, in accordance with a Conservative Party manifesto commitment. The legal basis for a referendum was established by the UK Parliament through the European Union Referendum Act 2015. Britain Stronger in Europe was the official group campaigning for the UK to remain in the EU, and Vote Leave the official group campaigning for it to leave. Other campaign groups, political parties, businesses, trade unions, newspapers and prominent individuals were also involved, and each side had supporters from across the political spectrum. Those who favoured a British withdrawal from the European Union, commonly referred to as a Brexit, argued that the EU has a democratic deficit, and that being a member undermined national sovereignty, while those who favoured membership argued that in a world with many supranational organisations, any loss of sovereignty was compensated by the benefits of EU membership. Those who wanted to leave the EU argued that it would allow the UK to better control immigration, thus reducing pressure on public services, housing and jobs, save billions of pounds in EU membership fees, allow the UK to make its own trade deals, and free the UK from EU regulations and bureaucracy that they saw as needless and costly. Those who wanted to remain argued that leaving the EU would risk the UK's prosperity, diminish its influence over world affairs, jeopardize national security by reducing access to common European criminal databases, and result in trade barriers between the UK and the EU. In particular, they argued that it would lead to job losses, delays in investment into the UK and risks to business. Financial markets reacted negatively to the outcome. Investors in worldwide stock markets lost more than the equivalent of $2 trillion on the 24th of June 2016, making it the worst single-day loss in history, in absolute terms. The market losses amounted to $3 trillion by the 27th of June. The value of the pound sterling against the US dollar fell to a 31-year low. The UK's and the EU's sovereign debt credit rating was also lowered by Standard & Poor's. By the 29th of June, the markets had returned to growth and the value of the pound had begun to rise. Immediately following the result, the Prime Minister David Cameron announced he would resign, having campaigned unsuccessfully for a Remain vote on behalf of Britain Stronger in Europe and HM government. He was succeeded by Theresa May on the 13th of July. The opposition Labour Party also faces a leadership challenge as a result of the EU referendum. In response to the result, the Scottish Government announced that it would plan for a possible second referendum on independence from the United Kingdom. and announced that it would like discussions with the EU institutions and other member states to explore all the possible options to protect Scotland's place in the EU. Meanwhile, Nigel Farage, leader of the anti-EU UKIP, stood down after his party's long-term ambition had been accomplished. History. The European Economic Community was formed in 1957. The United Kingdom first applied to join in 1961, but this was vetoed by France. A later application was successful and the UK joined in 1973. A referendum 2 years later on continuing membership resulted in 67% approval. Political integration gained greater focus when the Maastricht Treaty established the European Union in 1993, which incorporated the EEC. In the European Parliament election in 2014, the UK Independence Party secured a plurality of the popular vote, leaving the Conservative Party in third place. Given the electoral system for the European Parliament uses a proportional representation, UKIP also gained the most British seats in the European Parliament. While attending the May 2012 NATO summit meeting, British Prime Minister David Cameron, William Hague and Ed Llewellyn discussed the idea of using a European Union referendum as a concession to energize the Eurosceptic wing of the Conservative Party. In January 2013, Cameron promised that, should his Conservative Party win a parliamentary majority at the 2015 general election, the UK government would negotiate more favourable arrangements for continuing British membership of the EU, before holding a referendum on whether the UK should remain in or leave the EU. In May 2013, the Conservative Party published a draft EU referendum bill and outlined the plans for renegotiation and then an in-out vote if returned to office in 2015. The draft bill stated that the referendum must be held no later than the 31st of December 2017. The draft legislation was taken forward as a private member's bill by Conservative MP James Wharton. The bill's first reading in the House of Commons took place on the 19th of June 2013. Cameron was said by a spokesperson to be very pleased and would ensure the bill was given the full support of the Conservative Party. Regarding the ability of the bill to bind the UK government in the 2015-20 Parliament for holding such a referendum, a parliamentary research paper noted that the bill simply provides for a referendum on continued EU membership by the end of December 2017 and does not otherwise specify the timing, other than requiring the Secretary of State to bring forward orders by the end of 2016. If no party obtained a majority at there might be some uncertainty about the passage of the orders in the next Parliament. The bill received its second reading on the 5th of July 2013, passing by 304 votes to none after almost all Labour MPs and all Liberal Democrat MPs abstained. Cleared the Commons in November 2013, and was then introduced to the House of Lords in December 2013, where members voted to block the bill. Conservative MP Bob Neill then introduced an alternative referendum bill to the Commons. After a debate on the 17th of October 2014, it passed to the Public Bills Committee, but because the Commons failed to pass a money resolution, the bill was unable to progress further before the dissolution of Parliament on the 27th of March 2015. Under Ed Miliband's leadership between 2010 and 2015, the Labour Party ruled out an in-out referendum unless and until a further transfer of powers from the UK to the EU were proposed. In the manifesto for the 2015 general election, the Liberal Democrats pledged to hold an in-out referendum only in the event of there being a change in the EU treaties. The UK Independence Party, the British National Party, Party, the Green Party, the Democratic Unionist Party and the Respect Party all supported the principle of a referendum. When the Conservative Party won the majority of seats in the House of Commons in the May 2015 general election, Cameron reiterated his party's manifesto commitment to hold an in-out referendum on UK membership of the EU by the end of 2017, but only after negotiating a new settlement for Britain in the EU. Renegotiation before the referendum. In early 2014, Prime Minister David Cameron outlined the changes he aimed to bring about in the EU and in the UK's relationship with it. These were additional immigration controls, especially for new EU members, tougher immigration rules for present EU citizens, new powers for national parliaments collectively to veto proposed EU laws, new free trade agreements and a reduction in bureaucracy for businesses, a lessening of the influence of the European Court of Human Rights on UK police and courts, more power for individual member states and less for the central EU, and abandoning the EU notion of ever closer union. He intended to bring these about during a series of negotiations with other EU leaders and then, if re-elected, to announce a referendum. In November that year, Cameron gave an update on the negotiations and further details of his aims. The key demands made of the EU were, on economic governance, to recognise officially that Eurozone laws would not necessarily apply to non-Eurozone EU members and the latter would not have to bail out troubled Eurozone economies, on competitiveness, to expand the single market and to set a target for the reduction of bureaucracy for businesses, on sovereignty, for the UK to be legally exempted from ever closer union, and for national parliaments to be able collectively to veto proposed EU laws, and, on immigration, for EU citizens going to the UK for work to be unable to claim social housing or in-work benefits until they had worked there for 4 years, and for them to be unable to send child benefit payments overseas. The outcome of the renegotiations was announced in February 2016. The renegotiated terms were in addition to the United Kingdom's existing opt-outs in the European Union and the UK rebate. There was no fundamental change to the EU-UK relationship. Some limits to in-work benefits for EU immigrants were agreed, but these would apply on a sliding scale for 4 years and be for new immigrants only. Before they could be applied, a country would have to get permission from the European Council. Child benefit payments could still be made overseas, but these would be linked to the cost of living in the other country. On sovereignty, the UK was reassured that it would not be required to participate in ever closer union. These reassurances were in line with existing EU law. Cameron's demand to allow national parliaments to veto proposed EU laws was modified to allow national parliaments collectively to object to proposed EU laws, in which case the European Council would reconsider the proposal before itself deciding what to do. On economic governance, anti-discrimination regulations for non-Eurozone members would be reinforced, but they would be unable to veto any legislation. The final 2 areas covered were proposals to exclude from the scope of free movement rights third country nationals who had no prior lawful residence in a member state before marrying a union citizen, and to make it easier for member states to deport EU nationals for public policy or public security reasons. The extent to which the various parts of the agreement would be legally binding is complex. No part of the agreement itself changed EU law, but some parts could be enforceable in international law. According to reliable sources, the EU had offered David Cameron a so-called emergency break, which would have allowed the UK to withhold social benefits to new immigrants for the first 4 years after they arrived. This break could have been applied for a period of 7 years. That offer was still on the table at the time of the Brexit referendum, but expired when the vote determined that the UK would leave the EU. Cameron claimed he could have avoided Brexit had European leaders let him control migration, according to the Financial Times. However, that offer had not been made by the EU, as confirmed by Angela Merkel to the German parliament. If you wish to have free access to the single market, then you have to accept the fundamental European rights as well as obligations that come from it. This is as true for Great Britain as for anybody else. Means of withdrawal and precedents. There is no precedent for a sovereign member state leaving the European Union or any of its predecessor organizations. However, 3 territories of EU member states have withdrawn: Algeria, Greenland and St. Barthélemy, the latter 2 becoming overseas countries and territories of the European Union. Article 49A of the Treaty of Lisbon, which came into force on the 1st of December 2009, introduced for the first time a procedure for a member state to withdraw voluntarily from the EU. This is specified in Article 50 of the Treaty on European Union, which states that any member state may decide to withdraw from the Union in accordance with its own constitutional requirements. A member state which decides to withdraw shall notify the European Council of its intention. In the light of the guidelines provided by the European Council, the Union shall negotiate and conclude an agreement with that state, setting out the arrangements for its withdrawal, taking account of the framework for its future relationship with the Union. That agreement shall be negotiated in accordance with Article 218 of the Treaty on the Functioning of the European Union. It shall be concluded on behalf of the Union by the Council, acting by a qualified majority, after obtaining the consent of the European Parliament. The treaties shall cease to apply to the state in question from the date of entry into force of the withdrawal agreement, or, failing that, 2 years after the notification referred to in paragraph 2, unless the European Council, in agreement with the member state concerned, unanimously decides to extend this period. Coverage of the issue in The Guardian includes an explanation as to Article 50 and how it would be invoked. There seems to be no immediate legal means out of the stalemate. It is entirely up to the departing member state to trigger Article 50 by issuing formal notification of intention to leave. No one, in Brussels, Berlin or Paris, can force it to. But equally, there is nothing in Article 50 that obliges the EU to start talks, including the informal talks the Brexit leaders want, before formal notification has been made. There is no mechanism to compel a state to withdraw from the European Union, said Kenneth Armstrong, professor of European law at Cambridge University. The notification of Article 50 is a formal act and has to be done by the British government to the European Council, and EU official told Reuters. Remaining members of the EU consequently would need to undertake negotiations to manage change over the EU's budgets, voting allocations and policies brought about by the withdrawal of any member state. Some constitutional experts have argued that, under the Scotland Act 1998, the Scottish Parliament has to consent to measures that eliminate EU law's application in Scotland, which gives the Scottish Parliament an effective veto over UK withdrawal from the EU, unless the Scotland Act 1998 is amended by the UK Parliament to reduce the Scottish Parliament's current powers. After the Leave result was announced, on 26 June 2016. First Minister Nicola Sturgeon said she would, of course, ask the Scottish Parliament to withhold consent and thus block the UK from leaving the EU. However, this interpretation of the 1998 Act is disputed. For example, Section 28 of the Act states that it does not affect the power of the Parliament of the United Kingdom to make laws for Scotland. Legislation. The planned referendum was included in the Queen's speech on 27 May 2015. It was suggested at the time that Cameron was planning to hold the referendum in October 2016, but the European Union Referendum Act 2015, which authorized it, went before the House of Commons the following day, just 3 weeks after the election. On the bill's second reading on 9 June, members of the House of Commons voted by 544 to 53 in favor of it, endorsing the principle of holding a referendum, with only the Scottish National Party voting against. In contrast to the Labour Party's position prior to the 2015 general election under Miliband, acting Labour leader Harriet Harman committed her party to supporting plans for an EU referendum by 2017. To enable the referendum to finally take place, the European Union Referendum Act 2015 is passed by the Parliament of the United Kingdom, which is specially extended outside of the United Kingdom to also include and to also take legislative effect in Gibraltar, and receives royal assent on 17 December 2015. The Act is in turn confirmed, enacted and implemented in Gibraltar by the European Union Act 2016-034 as amended by LN 2016-035, LN 2016-082 and LN 2016-120, which is passed by Legislature of Gibraltar, also known as Gibraltar Parliament, which commenced on 28 January 2016 and received the assent of the Governor of Gibraltar on 28 January 2016. Administration date. Prior to being officially announced, it was widely speculated that a June date for the referendum was a serious possibility. The First Ministers of Northern Ireland, Scotland, and Wales co-signed a letter to Cameron asking him not to hold the referendum in June, as devolved elections were scheduled to take place the previous month. These elections had been postponed for a year to avoid a clash with the 2015 general election. After Westminster had implemented the Fixed-Term Parliament Act, Cameron refused this request, saying people were able to make up their own minds in multiple elections spaced a short time from each other. In February 2016, Cameron announced that the government was to recommend that the UK should remain in the EU and that the referendum would be held on 23 June, marking the official launch of the campaign. He also announced that Parliament would enact secondary legislation relating to the European Union Referendum Act 2015 on the 22nd of February. With the official launch, ministers of the UK government were then free to campaign on either side of the argument, in a rare exception to cabinet collective responsibility. Eligibility to vote. The right to vote in the referendum in the United Kingdom is defined by the legislation as limited to residents of the United Kingdom who were either also Commonwealth citizens under the British Nationality Act 1948, or those who were also citizens of the Republic of Ireland, or both. Members of the House of Lords were able to vote in the referendum. Residents of the United Kingdom who were citizens of other EU countries were not allowed to vote unless they were citizens of the Republic of Ireland, of Malta, or of the Republic of Cyprus. The Representation of the People Acts Chapter 1983 and 1985, as amended, also permits certain British citizens who had once lived lived in the United Kingdom, but had since and in the meantime lived outside of the United Kingdom, but for a period of no more than 15 years, to vote. Voting on the day of the referendum was from 0700 to 2200 BST in some 41,000 polling stations manned by over 100,000 staff. Each polling station was specified to have no more than 2,500 registered voters. Also under the provisions of the Representation of the People Act, 2,000 postal ballots were also permitted in the referendum and were sent out to eligible voters some 3 weeks ahead of the vote. The minimum age for voters in the referendum is set to 18 years, in line with the Representation of the People Act, as amended. A House of Lords amendment proposing to lower the minimum age to 16 years was rejected. The deadline to register to vote was initially midnight on the 7th of June 2016, but this was extended by 48 hours because of technical problems with the official registration website on the 7th of June caused by unusually high web traffic. Some supporters of the Leave campaign, including the Conservative MP Sir Gerald Howarth, criticised the government's decision to extend the deadline, alleging it gave Remain an advantage because many late registrants were young people who were considered to be more likely to vote for Remain. Almost 46.5 million people were eligible to vote. Crown dependencies. Residents of the Crown dependencies, namely the Isle of Man, the Bailiwick of Jersey and the Bailiwick and Islands of Guernsey, even if they were British citizens, were excluded from the referendum unless they were also previous residents of the United Kingdom. Some protests by some islanders were registered, who claimed that they, as full British citizens under the British Nationality Act 1981 and living within the British Islands, should also have been given the opportunity to vote in the referendum as the islands, although not included as if they were part of the United Kingdom for the purpose of European Union membership. They and the islanders would also have been significantly affected by the outcome and impact of the referendum. Referendum question research by the Electoral Commission confirmed that its recommended question was clear and straightforward for voters, and was the most neutral wording from the range of options considered and tested, citing responses to its consultation by a diverse range of consultees. The proposed question was accepted by the government in September 2015, shortly before the bill's third reading. The question that appeared on ballot papers in the referendum before the electorate under the Act will be in was, with the responses to the question to be, campaign. As of October 2015, there was a cross-party, a formal group campaigning for Britain to remain a member, called Britain Stronger in Europe, while there were two groups promoting exit which sought to be the official Leave campaign, Leave EU, and Vote Leave. The Electoral Commission announced on the 13th of April 2016 that Vote Leave was the official Leave campaign. This gave it the right to spend up to £7 million, a free mail-shot TV broadcasts and £600,000 in public funds. Leave EU also had an umbrella group offshoot, the cross-party Grassroots Out. The UK government's official position was to support the Remain option. A government-backed campaign was launched in April. On the 16th of June, all official national campaigning was suspended until the 19th of June after the killing of MP Jo Cox. Government distributed a leaflet to every household in England in the week commencing on the 11th of April and in Scotland, Wales and Northern Ireland on the 5th of May. It gave details on why the government's position was that the UK should remain in the EU. The rationale was that internal polls showed that 85% of the population wanted more information from the government. It was criticised by those wanting to leave as being an unfair advantage, inaccurate and a waste of money, costing £9.3 million for the campaign. In the week beginning on the 16th of May, the Electoral Commission sent a voting guide regarding the referendum to every household within the UK and Gibraltar, to raise awareness of the upcoming referendum. The 8-page guide contained details on how to vote, as well as a sample of the actual ballot paper, and a whole page each was given to the campaign groups Britain Stronger in Europe and Vote Leave to present their case.